Assalamualaikum to all my friends, especially my beloved lecturer, Miriam Siti Omira Omar. My name is Ammar Haziq bin Abdul Rashid, and my group has 4 people, namely Muhammad Syakir Aiman, Nabila, Muhammad Ruzaimi, and also me. We have got our assignment, which is on the topic of discharge of contract. So, what is the discharge of contract? Discharge of contract is when two or more parties enter into a contract. The contract imposes duties and obligations on each of them. This is also when a contract is discharged, it means that it is no longer active, terminated. When a contract is discharged, it is no longer active. The contracting parties are no longer bound by the terms of the agreement. Responsibilities under the contract. We know that there are 4 modes of discharge of this contract. Among them are by performance, by agreement, by frustrations, and lastly is breach. So we will explain one by one in detail and clearly about the 4 modes of discharge of contract. Alright, I will discuss the discharge of the deal or the agreement. An agreement is the decision between agree or disagree. Discharge of agreement is a contract formed by mutual agreement. It can also be cancelled or released by all parties who agree. An agreement to execute the contract can also be made after the contract is signed. Sections 63 and 64 of the Contract Act 1950 for this. We have 2 parts, namely Section 63 and Section 64. For Section 63, if the parties to a contract agree to replace it with a new contract, cancel it or vary it, the previous contract shall not be fulfilled. Further, for Section 64, every promise is entitled to distribute or transmit in whole or in part. In part, the fulfillment of his promise to him, or perhaps making such an offering last longer, or being able to receive the satisfaction he feels he deserves in return. Based on the above 2 parts, the agreement to perform the contract can be in the following forms. First, novation. Second, alternations. Third, rescissions. And lastly, remission. Next, I will pass the Syakir Aiman to present about discharge of by performance.
So next, we go to the discharge by performance. In order to discharge a contract by performance, both the express and implied term must be performed. Under the contract, when both parties have fulfilled all of their responsibilities, there are 2 different types of performance. First, the strict contractual obligation, and second, the qualified contractual obligation. A strict contractual obligation is a strict obligation which must be met. This obligation will usually use definitive words such as must or will, and will discuss a definite result rather than an aim or a target. So for the example, A must do B. Okay, so strict obligation must be fulfilled before a contract can be discharged for completed performance. Excuses as to why an obligation could not be fulfilled will not be sufficient. Next, the qualified contractual obligation. Qualified contractual obligation is different to strict obligation as they are not definitive. Qualified obligation will not have to result in a specific outcome. The obligation will be to perform to a standard. So the most common example of a qualified obligation is to exercise reasonable care and skill. Section 38 Sub 1. The parties to a contract must either perform or offer to perform their respective promise unless the performance is dispensed with or excused under this Act or any other law. If the time of the performance of the contract is essential, important, any delay by one party, however slight, will entitle the other party to free himself from any obligation of the contract. That is to treat the contract as voidable. So, the parties must perform contract within stipulated time. Next, Section 41. If it appears from the nature of the case that it was the intention of the parties to any contract that any promise to contain in it should be performed by the promisor himself, then it must be performed by him personally. If the promisee accepts performance from a third party, he cannot enforce it anymore against the promisor. So we go to the Section 42. Says when a promisee accepts performance from the third party, he cannot enforce it anymore against the promisor. So Section 50. When a promise is to be performed without any application by the promise and no place is fixed for the performance of it, it is the duty of the promisor to apply the promisee to appoint a reasonable place for the performance of the promise and to perform it at that place. So, if it is the intention of the parties that the contract should be performed by the promisor himself, then it must be performed by him personally. Next, Section 56 Sub 1. When a party to a contract promise to do a certain thing to at or before a specified times and fails to do any such thing at or before the specified time, the contract or so much of it as has not been performed, so becomes voidable at the option of the promisee in the intention of the parties, or the time should be of the essence of the contract. If there is a place being specified for the performance of the contract, the parties must perform to the contract at the place specified. If there is no place specified, the promisor is under a duty to ask the promisee to specify the place of the performance of the contract. So I think that's all from me. So we move to the next presenter.
I will explain about frustration of contract. Concept of frustration. First, frustration occurs whenever a contract after its formation becomes impossible to perform without the fault of either party. The doctrine is often called subsequent or supervening impossibility, and its effect is that the parties are released from their contractual obligation. And second, when the party by his own contract creates the duty or change upon himself, he is bound to make it good, if he may, notwithstanding any accident, by inevitable necessity, because he might have provided against it by his contract, and therefore, if the lessee convenient to repair a house, though it be burned by lightning or thrown down by enemies, yet it ought to repair it. The definition of frustration. A contract is frustrated where, after the contract was concluded, unforeseen events occur which make performance of the contract impossible, illegal, or something radically different from that which was in the contemplation of the parties at the time they entered the contract, and neither party must be at fault. A contract is discharged if there is impossibility of performance of the contract. It may happen in two situations. First situation is the contract is in itself impossible to be performed, and second situation is the contract become impossible to be performed after it has been made. 4 points in frustration of contract. First, destruction of the subject matter of the contract. It means the destruction of the subject matter of contract would frustrate the contract as the contract become impossible to be performed as contracted. Second point is there is supervening event which defeat the whole purpose or object of the contract. It means if the contract is entered into for a specific purpose known to the other party and something happen beyond the control of either party which results in the purpose of the contract to be defeated, the contract is frustrated. And third point, death or personal incapacity. It means a person who is deceased or incapacitated cannot perform the contract. This is so if it involves personal obligation such as contract of service. Hence, the contract is frustrated due to death and personal incapacity. And last point is there is a change in the law which made the contract become unlawful if it is performed. Consequence of frustration. Frustration terminates the contract automatically, therefore the contract is void as it is impossible to be performed. Under S66, any person who receives advantage under the contract is bound to restore it to make compensation for it to the person from who he received it.
Hi, my name is Ruzaimi and I will continue the slideshow. Okay, my point is discharge by breach of contract. A contract legally enforceable promise. The promise is usually for the purchase of an item or for the service or job rendered. Then, if the party breaks the promise, the other party may be able to sue for breach of contract. It also means the failure of a party to perform or fulfill its obligations under the contract. Okay, the first one is anticipatory breach. Is when the party's contracts refuse to perform this part of the contract before the due date of performance. And second one is actual breach. When a party totally partially fails to perform it is obligation under the contract of the due date of performance or during the performance. And I will continue to the second topic, that is remedies. Okay, remedies, it is means given by law for the enforcement of a right. A right occurring to a party under a contract is meaningless if there is no remedy to enforce that right in the event of its violation. In that case of the breach of contract, the injured party as the one of more other following remedies: rescission of the contract, compensatory damage and other damage, quantum merit, specific performance of contract, injunction, etc. But here I'm going to define all of them, only two. Compensatory damage is the commons or the legal remedies for breach of contract. The calculation of compensatory damage is based on the actual losses you have sustained as a result of the breach of contract. They typically fall into two categories, which is expectation damage and consequential damage. Expectation damage, also referred to as general damage, are those that directly result from the breach of contract, while consequential damage are those that flows as a natural consequence of the breach. Consequence damage often comprise of profit that a company lost as a result of the breach. Often, the breaching party will attempt to avoid paying consequential damage by claiming that they are too speculative or they are not forcible. Also, sometimes parties to a contract may limit or preclude either party or recovering consequential damage. Explain attorney can also help these arguments and maximize damage award. And second one is injunction. Injunction serve a similar purpose as specific performance. The difference is that will specifically performance, the court orders a party to do something. With an injunction, the court often orders a party not to do something. An injunction may be permanent or temporary. Temporary injunctions are often ordered while a legislation is pending to prevent potential damage. Okay, that's all. Thank you.